Good afternoon, Ms. Bergerman. Good afternoon, Ms. Bergerman.
Good afternoon, Your Honor.
Good afternoon, Mr. Schulman.
Good afternoon, Your Honor.
I have a Manny in the waiting room. Is that your client, Ms. Bergerman?
Yes, it is, Your Honor.
Okay, bringing him in. Okay. Mr. DeSalva, can you hear us? It looks like he's connecting to audio now.
Can we request he connect to video as well?
I don't think we're taking evidence, so not sure it'll matter at this point, but he's just getting on right now.
I think I'm on, Your Honor.
Okay, good morning or good afternoon.
Good afternoon.
Are you able to put on video?
Oh, this is my first time using this, so I apologize.
How did you make it through an entire pandemic without having been on video? That's amazing.
I know. I'm just my 7-year-old nephew actually taught me how to do this.
Okay. All right. Well,
you guys,
we
but
don't have to. While we're gonna talk a little bit while you're trying to figure it out, and if you can't figure it out, then that might be okay. We'll see. We're here on Marino versus DeSalva, 20 DR 38. Please enter your appearances.
Romando Marino, the mother and petitioner, or at this point, it's petitioner in a separate case. It's going to be Ross Shulman from Woodward, Piers, and Lombardo.
Okay. And Ms. Bergerman?
Vera Bergerman, on behalf of Manuel da Silva, respondent's former husband.
Okay. Mr. Shulman, we're here on your motion to continue. I took this as quickly as I could because I realized that you had something on Monday, but if you can tell me about what it is that you're seeking and why I should grant a continuance briefly.
So very simply, we go to mediation not to check boxes. We go to mediations to speak about the issues in the case and try to settle cases. I don't think it would be fair to mediate this case on Monday with a motion for summary judgment on the pleadings outstanding right now. If this case is ruled on and the pleadings don't hold water, there's absolutely nothing for us to negotiate or talk with. So until that can be resolved, I don't know how in good faith I can advise a client into any kind of settlement or any kind of deal.
Isn't the issue have to do with child issues?
Yes.
What's outstanding right now is there are domesticated New York orders, final orders by agreement, and they've got a supplemental petition to modify them. So before we can get into discussions about any of this, if this petition gets knocked out, there's no case, there's nothing to address.
Yeah, but does that mean that these issues relating to parenting time are going to go away? Won't they just come back in another form?
So the fact of the matter is that if this case is surviving and it's a case where it is proceeding through litigation and there is a high likelihood or any likelihood that this supplemental petition, that the orders and everything that are coming from New York may or may not be changed, then the conversations we're going to have about trying to reach agreements go to a very different place. If we believe that the actual pleadings themselves are going to fail and there is no case pending, my client has absolutely no incentive to discuss or address anything at this point.
Okay, Ms. Bergerman?
Yes, Your Honor. The issue here, we believe, is that this motion is actually being made in somewhat bad faith. And the reason I use that term very carefully is because there had been previously a motion to dismiss in this case, our supplemental petition. This was heard, this motion to dismiss by you, and you did not grant the motion to dismiss. Our pleading was answered, and we then set a motion for temporary relief. And we heard through your JA that Your Honor wanted this set for mediation prior to setting a hearing. And that is indeed what happened. There was an order.
Was that pursuant to the standing order? Because this is time sharing issues?
It was the order appointing and directing schedule mediation, Your Honor, was pursuant to Chapter 44 and Florida Family Law Rules of Procedure 12.740 and 12.741. You issued this order on 4/26, and the mediation is scheduled for Monday, May 24th. The next thing that happens is that Mr. Schulman on May 12th filed a motion for judgment on the pleadings with incorporated memorandum of law. However, it is word for word, with the exception of the title, the same thing as the one that you dismissed. So we believe that since we, and there's one other thing to note of importance about this, and that is a case of Domres, D-O-M-R-E-S, appellant versus Perrigan, P-E-R-R-I-G-A-N. And this is 760 Southern 2nd, 1028 from the 5th District Court of Appeal, June 16th, 2000. And it says, a motion for judgment on the pleadings is determined by the same legal test as a motion to dismiss a complaint for failure to state a cause of action. Kastner v. Ziemer, Florida 2nd DCA, 1959. And a defensive motion for judgment on the pleadings is submitted to the same legal test as a motion to dismiss, Kastner. So we believe that this will also fail, but in the meantime, we cannot set anything for hearing, our temporary motion for relief, because Your Honor ordered us to mediation, and now our mediation is being delayed. So I see two solutions to this from my perspective. One is that Your Honor could deny their motion to continue. We would then go to mediation. However, I think Mr. Schulman and I both agree that with the mindset of the parties at this moment, it is not likely to resolve successfully. One never knows, of course. That's the beauty of mediation. But given the approaches taken by the former wife to our pleadings, it would be reasonable to assume that. So we would also be fine if Your Honor wanted to schedule our hearing. And if you are going to have a hearing on Mr. Schulman's motion for judgment on the pleadings with incorporated memorandum of law, then it would be appropriate to have them both heard at the same time. And it would prevent any further delay from my client. Thank you.
Or what two things to be heard at the same time?
Well, again, Mr. Schulman.
I know the motion for judgment and pleadings and what else?
Oh, our motion for temporary relief.
Okay. All right.
Your Honor, may I just respond very briefly, only because there was an accusation of bad faith, and there was.
I don't need to hear a bad faith. Doesn't matter.
Our motion was within 2 weeks of the court order. That's.
I got it. I'm not. That wasn't important to me.
And additionally, I disagree with that analysis, and I would like a hearing on our summary judgment on the pleadings. When you're looking at whether or not a petition holds enough water to move on versus whether what's stated in the petition, if it does hold water, is anything that can be won on, are two very different issues. So I don't agree that it's the same motion. If you look at the two, the language has changed, the standards and case law and everything I've added in there has actually changed between the two. It is not a
I agree. It
motion.
is a different standard, but I think we're left with the same problem. Just because somebody files that type of motion, it doesn't mean everything else in the case needs to stop.
Correct, but it was filed within 2 weeks, Your Honor. And like I said, at this point, for us to mediate something, I just don't know how I can advise a client to give anything.
Let me ask you this, Mr. Schulman, because here's what I'm not, even if you won, let's play this out. Even if you won your motion for judgment on the pleadings, don't you think this case will come back in some form if they change their pleadings and amend? Because in some way he's going to want to amend his pleadings as it relates to time sharing. So how can mediation hurt this in the long run?
Well, what would have to happen is he would have to take a third bite at the apple to try to find some significant, substantial material change of circumstances since the time those New York orders were put in place. He hasn't done it the first time, and I don't believe he's done it the second time. If he never gets that done, then the mediation, the costs associated with the same, the conversations, the stress levels, everything I'd be asking my client to participate and do should never come to fruition. And if he continues to plead and continues to fall short, it is what it is. But I can't in good faith ask a client to commit the energy level, the stress, and a good faith effort to try to resolve a case, believing firmly that this case should not proceed as it is currently presented to the court.
Okay. Well, the good thing about mediation is that you don't have to proceed just based on what's currently in front of the court. The parties are free to come to a more global resolution and talk about things that obviously will come back at some point. So I'm going to deny the motion to continue at this time. It is important to have the mediation, and it will happen. It's required under the standing rules before I can hear on the motion for temporary. And I'm not prejudging whether or not I would grant any relief on that motion for temporary, just like I'm not prejudging whether or not I would grant your motion for judgment on the pleadings. But based on the standing order, I can't even hear their motion until you've all gone to mediation. We'll work on getting I do want to require Ms. Bergerman to file a response to the motion for judgment on the pleadings, and then we can set it for a hearing. But I'm going to deny the motion to continue. Ms. Bergerman, can you please prepare that order?
Okay.
And Ms. Bergerman, how long do you need to respond to the motion for judgment on the pleadings? I realize it was just filed on the 12th.
2 weeks.
2 weeks?
I mean, I can make it less if Your Honor.
2 weeks seems very reasonable to me.
Okay.
So and then you both can work on getting that on the calendar, because if it's granted, then the case is done. But the parties' relationship isn't going to be done. So I'm not sure what the end game is.
Okay.
All right. Any questions regarding the court's order, Ms. Bergerman?
No, Your Honor. I'm also your next one up at 1:30.
Okay, so I'll keep you on. Any questions regarding the court's order, Mr. Schulman?
No, but before we sign off, I know that you squeezed us in here, and I'd just like to thank Attorney Bergerman for helping this happen, and certainly you for taking the time.
No problem. Happy to help.
Have a good weekend,
Yes,
everybody.
thank you, Your Honor.
Thank you, Your Honor.
Okay, Stephanie. Good afternoon, Ms. Orell.
Hi, good afternoon.
Good afternoon, Mr. Orell. Can you hear us? I don't think he's connected to audio yet.
I'm on the audio now.
Okay, excellent. Are you able to put on your video, Mr. Orell?
Yes, I am.
Awesome. All right. Good afternoon, everybody. We're here on obviously Orell versus Orell, 19 DR 1212. Ms. Bergerman, can you please enter your appearance?
Yes, Attorney Vera Bergerman on behalf of Stephanie Orell, who is also present via Zoom.
Okay. And Mr. Orell, you are still not represented, right?
That's correct.
Have you made any attempts to get representation since last time we were here?
I have.
How's that going?
Well, they always tell you what you want to hear, but whether or not they're going to do that is
Okay.
not.
Well,
for so.
Obviously, we're still on the trial docket. I had set this case for case management because I kind of wanted to see how it was going as after our last, how we ended last time, to see if things have been complied with, what things have changed, if anything, if the house had been sold, things like that. So Ms. Bergerman, just starting with you, can you kind of report on what the status is since our last time together?
Yes, Your Honor. Okay. I'm looking at my notes here. The first thing we did from our office following the April 20th trial was we spoke with Mary Shorak, the reunification counselor, and emailed her a very simple proposed order for reunification for her comment. She was delayed in responding to us because her husband is hospitalized, unfortunately. But she did say she was willing to take the case, and she would like to have the order be a little more involved than what I did, but I do have a simple one prepared that would be immediately available. Then the next thing that happened is we prepared our comprehensive order from April 20th. I emailed it to Mr. Arell for his approval. It appears that he didn't quite understand what I was doing in terms of, because of course he's not counsel, and he doesn't know that generally what we do is we mail it to the other side for their approval. Although I did try to make that clear in my accompanying email to him. But what Mr. Arell did was he went to work and he submitted his own order to your judicial assistant. And since he had submitted his order, I then formally submitted mine to Cheyenne with a cover letter. The order came in signed by you this morning at approximately 9:27. We got it to our client right away, and I had Stephanie call Mary Shorak's office, and I'm going to proffer that what they said was they could fit in the Arells a week after next week for an appointment, but that they did wish to speak with the parties next week to set something up.
Wonderful.
Next thing is I had my client, Stephanie, speak with Carmen Rodriguez of the Family Resource Center. And again, I'm proffering this. She said to Stephanie that Mr. Arell has to go first with filling out their paperwork, and that Stephanie should call back again mid next week to see if Mr. Arell has. And of course, our order does contain the phone numbers and addresses for everyone. The next thing that was in the order, another thing that was in the order is you did specify that there is to be a return of the memory boxes, the Christmas decorations, and Stephanie's grandma's dishes before the house closes. I did receive word that the house was supposed to close today, but as I explained to the title agent, we did not have an order yet, so I could not release my lease pendants. So Mr. Arell might be able to update us on that.
Let's do that. Mr. Arell did it. What's going on with the house?
We have a continuation of closing because of the lease pendants.
Oh.
When's it set for?
That's
We requested a week.
Okay.
Okay.
We have the release of lease pendants already prepared, Your Honor. We were simply waiting for your order to come through, so we can get that. We can get that off. And
okay, now that the order's through, we can. The order's through now. That order. Okay.
Yes.
All right.
And
my apologies for not getting out the order ahead of time. Had I realized it would have delayed closing, I would have prioritized it even more than I did. Okay, thank you.
And the last item, Your Honor, is the FaceTime. I understand that the parties have not engaged in FaceTime between the father and the children. Ms. Orell did not initiate it, and Mr. Orell did not initiate either, even though both of them are familiar with the phone numbers involved. I believe I'm going to proffer Ms. Orell thought she was supposed to wait for an order, and she's very, very sorry about that. But Mr. Orell didn't try to call, according to Mrs. Orell,
Well,
although he addressed it in pleadings.
okay.
In
Well,
motion.
now that the order is signed, let's make sure that this FaceTime happens going forward. Is that understood by everybody?
Yes, sir.
Yes.
Okay. All right. I apologize for cutting you off, Ms. Bergman. I do have a limited amount of time. Mr. Orell, just from you, well, first of all, has all the, other than has the memory boxes and the baseball equipment been returned, or is that still an issue?
I returned the baseball equipment due to it was contaminants of her repossession of her automobile. All of the personal effects from her automobile was delivered to Mrs. Bergman the following day.
Okay.
Correct.
All right. Thank you.
Just not the memory boxes and the dishes and things that are supposed to happen before closing.
Okay. Mr. Orell, just give me an opportunity to let me know what's happened since that I need to be aware of since the last time we met.
Nothing's happened except the duration of, or continuation rather, of the sale of our home.
Okay. All right. Well, I'm glad it's still going to happen. And now the lease pendants can be removed. And hopefully that will help some of the financial situation.
Well,
Obviously, now it seems like there was a misunderstanding relating to the FaceTime. I guess let's talk now. Who wants to, Mr. Orell, can he be the one initiating this? Is there any issue with him initiating it when he wants? As far as the FaceTime communications? Because it seemed like there was a confusion of who was supposed to initiate.
I believe in our order, it's supposed to be Wednesdays at 5:30, which I'm good with. It doesn't matter if he initiates it that day or I call. I'm fine with whatever.
Okay, Mr. Orell, do you want to be the one initiating on that day and time?
I would like to initiate that day and time and additional times and days as well. One day a week for FaceTime doesn't seem enough for the support allegations provided to the respondent.
Okay. Ms. Bergman, there's nothing set to add additional FaceTime today, so unless there's consent as to additional times, and maybe we can talk about that. I don't know if your client consents to additional times.
Well, Your Honor,
but
I think
it does.
Given that we're going to be back in front of you again on June 9th, and everybody is supposed to speak with Carmen Rodriguez of the Family Resource Center and Mary Shorak from the offices of Gunder and Shorak. I think that our time is better spent getting going on those two very significant processes. That's just my thought.
Okay. I mean, there's nothing contested in front of me today. I do think it's possible to walk and chew gum at the same time with these things. So if you and Mr. Orell, Ms. Bergman, can communicate about potentially, and if there is some agreement of additional FaceTime hours for him, that's great. If it has to come to me in front for a motion before then we'll have to deal with it then. But yes, I do. I agree with you to the extent that it's very important for us to start the reunification process. It was delayed a little bit because of these orders. But now that we have the order down, there shouldn't be any more delay. And it sounds like you've done a good job of at least getting to the point where now they all will communicate next week with the therapist and potentially have a first meeting the following week, right?
Mm-hmm. Yes.
Okay. Excellent. Well, all right.
I would like to know when Mr. Orell is anticipating bringing these items by my office.
The memory boxes?
Yes, and the grandma dishes, and I think it said Christmas ornaments too.
Mr. Earl, do you have an ETA on those?
I addressed in my formal motions last week after our court date that there was no more items belonging to the respondent here at the home. Moreover, I included 32 pictures of the children's belongings that the respondent has no intent to find out if the children still want them or if I can deliver those items to the children as well. So
Okay, so you have those items and you just want to see if she wants them as well?
Well, I know that the children want them. If I'm leaving the residence, I need to know what to do with these items. There's over 300 items belonging to both children.
Ms. Bergman, do you know your client's position on whether or not she wants these items?
Your Honor, my client had requested on April 20th that she be allowed to go through the house with, you know, perhaps an off-duty law enforcement officer with her to get some things and be able to look at them. And we came up with—
Can we just do this through pictures? He obviously put pictures in motion, in a motion. I mean, can't you just see what it is and see if she wants it? Do we have to really get an off-duty cop for this?
At my expense?
Well, Your Honor, it's because Mr. Arell has a domestic violence injunction.
I understand.
Right. Well, Stephanie, I turn this to you. This is not a particularly legal matter so much as it is a personal family type thing. So I defer to you.
I don't mind doing it through pictures. I haven't seen the pictures. If they can be sent to me, then I would love to go through them and sit down with the children and see what they would like and what they wouldn't like. I'm okay with that.
All right.
But my concern, Your Honor, is the issue of the memory boxes and the grandma dishes.
Obviously, the memory boxes are some of the most important things, Mr. Orell. What's the status on that?
I do not possess any memory boxes at all.
Are we using the wrong term? Because I thought I remembered you knowing what she was talking about.
I remember that there was little mailboxes. I believe that's what she's talking about, and they are not in this home. They were taken, part of the pictures that I motioned to the courts last week. They were part of the pictures of how many belongings she had removed from this residence on 2 occasions. The first occasion being 2019, when she and her father came here while I was at work and removed truckloads of her belongings and left every belonging of the children.
So what you're saying is you don't have anything that meets that description anymore?
That's correct. That's what I meant. Yeah.
Okay.
Now it's interesting. It sounded different on April 20th, especially when Mrs. Orell specified that they were in the top of a closet in the children's rooms, and Mr. Orell said, "Oh, I didn't even look there."
I'm trying to look at my notes because I do remember something about that. What were you talking about on top the closet, Mr. Orell? Like, wasn't there something that you told at trial?
I specified at trial that there were numerous items in the kids' rooms that needed to be dealt with, and they may be at the top of their closets. However, I have since packed all belongings of the children and my belongings, some of them right behind me as pictured.
Okay.
And these items need to be secured by myself, and there were no mailboxes involved.
I guess, is this a mailbox, Mrs. Orell?
Small, like, storage bin. It's like a clear bin with a lid, and there was 2 of them on top of the children's closets.
All right. I'm trying to look, and I do have that in my notes. that I did, and I don't necessarily see it in the order, but I did say that there would be that on May 21st, there could be a walkthrough with an off-duty officer of the house. Obviously, May 21st is tomorrow, so that's not going to happen, but we can schedule it for some time during the next week. Ms. Bergerman, can you just prepare a short order with a date and time that works related, and we'll have an off-duty officer go through with Ms. Orell.
Okay.
What day works for you, Mr. Orell, on that?
I guess if this is so important to the client that it holds up everything that we're involved with, especially reunification.
It's not holding up anything. It's not separate and apart from reunification, separate and apart from FaceTime. It's not holding up anything. We can walk and chew gum.
It doesn't seem like it from my standpoint, Your Honor. It seems like the only thing that they're interested in is money and their belongings, and not whether or not the father can see the children, which is the only thing I have ever motioned for in the last 2 years.
Okay.
So I will make myself available whenever is necessary.
Okay. Then Ms. Bergerman, you prepare an order and work with your client just on the time when we'll do that, when you guys can do that walkthrough. As soon as possible, I'll sign it as soon as it comes to me.
Okay, thank you.
And Mr. Orell, please recognize that everything we're doing is designed to get you back with the children. That's what reunification therapy is about. That's what the FaceTimes are about. All of this is designed to do that. Okay, I've run out of time.
To do that as well?
What?
Then the Liz pendants was designed to do that as well?
Well, the Liz pendants was something different, and now that's gone. All right. Best wishes to all of you. I hope that you can cooperatively work together, and I hope that reunification therapy is a really good step into bringing this family back together. We'll see you soon, and best wishes and a good weekend.
Thank you, Your Honor.
All right. Good afternoon. One second.
Good afternoon.
All right. Good afternoon, Mr. Lombardo.
Afternoon, Your Honor.
All right. Are we all ready to go back on the record?
Yes, Your Honor.
All right. We are here on, I guess this is technically the fourth trial day
Yes, sir.
in
Yes.
Pinio versus Asensio. Where we left off was with Mr. Asensio's, was in the middle of direct examination. I did reserve ruling on the exhibits 17 through 20 on Ms. Lanier's request for judicial notice. Last night, I reviewed the judicial notice statutes and made in the exhibits, and I am now comfortable of admitting those 17 through 20 through judicial notice. I guess before we begin, I think we kind of need to understand a little bit about what's coming up, because we don't have as much time as I know we would have wanted to have today. And it just looks like, given that Mr. Asensio is not even on cross yet, that this is going to be a trial that's not going to finish today. Miss Lanier, what's your sense of how long this would be going with Mr. Asensio on direct?
Well, Your Honor, I have some questions for him, and then we need to go through the 19 factors. So I would imagine an hour or so. It could be longer. It could be.
Gosh.
Yep.
An hour or so. And I suppose you don't have any understanding of how long it would take for a cross on that, Mr. Lombardo.
No, it's kind of hard to judge when I'm not sure where we're going exactly. But I wouldn't think it's going to be less than 45 minutes. I mean, it's probably an hour there as well. And we're 2 o'clock, we're pretty much there.
So basically what we'd be looking at is the entire day with Mr. Asensio at best. And then Ms. Lanier, would you have other witnesses?
Yes, sir. Ms. Pino?
Oh, you would call Miss, okay.
Yes, sir, but Mr. Lombardo and I are trying to discuss whether we're going to just let him use, call her, and I would not be prohibited at that point from using her in my case as well, just to speed things up.
Okay. Mr. Lombardo, how many witnesses do you anticipate in your case?
I've got 5, I believe is what we have.
5, and how many trial days do you think that would be?
That's well, and I know we were doing half days. I mean, it's probably 2 half days, maybe slightly longer, depending on how long it takes with Miss Pinot.
Well, will we be doing half days in the future?
Well, I guess the question is Mr. Lombardo and Miss Lanier, are you available Monday afternoon next week?
I am not.
Then that's the only half day I'd be able to offer next week. I guess the problem then is we'd be looking out quite some time to get the rest of the testimony on the record. Because I think I'm pretty booked up in June, so we'd likely be looking at sometime in August to continue this too. Do you all mind going off the record for a moment?
Don't mind.
All right, Ms. Mullen, we're off the record. Man, that was a long few half days. I do appreciate everybody accommodating this and doing this on a half days, but this has been an exhausting trial. You guys, Miss Pino and Mr. Asensio, you guys got to be exhausted too, right?
I am.
It's pretty clear, pretty painfully clear, that there's no way we're going to be finishing today. And if there's no way we're going to be finishing today, then it doesn't look like we would be able to finish for quite some time, given the other rest of the trials that we have in the summer months. Let me tell you a little bit about what I observed so far during the course of this trial. And I don't know if this is going to be helpful or not, and this is not a ruling by any stretch of the matter. This is just me kind of telling you what I've observed so far. Under the law, in order to modify a parenting plan, you need to show substantial, material, unanticipated change of circumstances. What that means from a layman's perspective is something had to fundamentally alter the relationship between the parties and the children. There's some examples of times when that happens, some of the more obvious examples. Let's say a parent lived in Naples and moved to North Carolina. Or let's say a parent had a medical issue and was no longer able to take care of the children. Those are easy examples of fundamental changes of circumstances. The other thing under the law is the burden of proof in this. It's an extraordinary burden of proof. That's the words that the courts use, is extraordinary. That's much higher than a preponderance of the evidence standard. And preponderance of the evidence, on layman's terms, is just, if you're playing football, it's just bringing the ball right over the 50-yard line. Clear and convincing is a higher standard of proof. That's bringing it basically into the end zone. Extraordinary is even higher than that. It's a very high burden to meet. Most of what I've heard about so far in this trial is just about incidences, and it's just about occurrences. There's nothing that I'm hearing right now that shows a fundamental change in the relationship between the parties and the children that would warrant some sort of change to the existing parenting plan. There's just nothing fundamental. It seems that's more of what's happening is just this trial is kind of devolving into she's done this wrong or he's done this wrong. types of things, which really wasn't the intent of the law when we get to modification for substantial and material change of circumstances. On issues related to children, there are no winners in family court. And the reason that there's no winners is because almost whatever happens, almost no matter what happens, and no matter what will happen as a result of this trial, you all are still going to be the parents of these two girls. And you're still going to have to be in a position to co-parent with them. No parent is going to be denied. If the intention is that Ms. Pino will be denied all time sharing with the children, that will never happen. Or can't imagine a circumstance where that would happen. Something extreme would have to happen, and then we're not there. If the intention is to deny Mr. Asensio time with the children, that's not going to happen. He's obviously, been a good father for a long period of time. So I'm not sure what victory looks like in this trial, but I kind of know what defeat looks like. Defeat here is these children not getting the attention or the needs fulfilled by their parents. And I'm very afraid, from everything that I've heard so far, that both of you are using your energies fighting each other, when what we should be doing is using our energies fighting for these two girls, especially one who seems to be manifesting some issues, mental health issues that seem very clearly to be attention grabbing, cries for a more needed attention. And that seems to be, from what the evidence I've heard of what the Baker Act was about. Doesn't seem to be the issues didn't seem, from what I've heard, to be about either one of you as parents. It seemed to be about things that were going on with the daughter and her need for an attention. I know this case has a long history and a lot of things have happened before I've ever seen it. And obviously these girls are getting older, nearly teenagers. I know I'm not the first judge, but I want to be the last judge. I want to be the one that ends the constant coming to court and does something to help reunify this family. And again, not your relationship. It's obvious to see that Ms. Pino and Mr. Asensio, you're not going to have any type of relationship together anymore, but you do have to co-parent. So those are my thoughts. And so I think that we're going to be able to continue this trial, but it's not going to be for a while. And I'm concerned about, in the meantime, what we're going to do to reunify this family. I think my initial thought is that we need to order some sort of family therapy. I understand that the girls are seeing, or at least one of the girls, I think it was Lydia, was seeing Dr. Frazier individually. It's not apparent to me that the family is doing anything either together to have a therapy to reunify. Am I correct on that, Ms. Lanier?
Yes, sir. Both girls are seeing Dr. Frazier.
They're both seeing Dr. Frazier, but Dr. Frazier's not providing family therapy, is she?
No, sir. Individual counseling, and my client's been in individual counseling as well with a different therapist.
What, Ms. Lombardo, is that correct? There hasn't been any type of family therapy?
That's correct.
I'd love to order it. I think that it's important, and I think it's something that we can do now before getting to the end of this trial, which obviously, if we get it done before the end of the summer, we're being ambitious, but that's what we're going to try to do. So what I'm going to do is I'm going to order this family to go to family therapy. I don't have somebody in mind right now, but what I'm going to do is I'm going to ask Ms. Lanier and Ms. Lombardo to communicate about maybe you could come to an agreement about a family therapist, and if not, I'll have each of them submit to me their top 2 names, and I'll just pick. I think that that's an immediate thing that could help, because again, no matter what the outcome of this trial is, I don't think it's going to result, it will never result in one side getting no more parenting time. It'll always be co-parenting until both of these girls are 18 years old. So we need to get you across that finish line. What else could we?
Can I make a recommendation, given the volume of emails and text messages and whatnot, that we ask them to use something like an Our Family Wizard or whatever the other app is, so that
I think that that's probably a really good recommendation. Are you guys familiar with the app?
Are you?
Yes, I've heard of it before.
Okay, so
have it on your phone. So
yes.
One thing that's kind of come apparent during this trial is that there's a lot of different ways. You guys aren't communicating that much or that well. And it does seem like when you are communicating, there's a lot of different ways that it's happening. The idea and the goal of My Family Wizard or that type of application is to get all of that in one place, so that you all have almost a place where you could communicate with each other just about the children. It's a really good program. Many parents have found it helpful. It's a good suggestion, Mr. Lombardo. Ms. Lanier, how do you feel like that would be helpful in this case?
I think it's good because you can not only communicate with each other, you can put schedules on there, and you can put receipts, bills, invoices, so we all are on the same page.
Yeah.
And it's monitored. I don't know if the clients know this, but it's monitored. And that way we're just going to strictly business and not any personal attacks from either party. I'm not blaming either party. I'm just saying.
Oh, and that's great, because that way, when you do something like that, it means that that's going to be your only method of communication. And it'll cut down on any of these things. Obviously, there's exceptions in case of emergencies, like if a child there's an emergency situation, obviously you can call in that circumstance, but it would be a great way to centralize the communication that you both are going to have. So if there's no objection by either side, I would love to put that in an order.
No objection.
Sure.
Yes, there's no objection. Your Honor, I do have questions on the therapy.
Yeah.
My concern is that if the parties think the therapist is going to testify, it's not going to be very helpful. I would ask that there be privilege so that they can get something out of it, as opposed to, I'm not saying any party's going to do this, but, thinking that this person's going to come testify.
Yeah, I don't want this therapist to be used as a tool to come before me. That's not what it's about. I don't want to hear from him. Him or her, whoever it is. I want that therapist to feel free and unfettered to be able to do what they need to do and I want the parents to feel that way too. So yes.
And then I'm sorry.
Absolutely. That should be confidential.
And then each pay their own and split the kids, or the kids according to their, they each pay there's been a problem with my client receiving child support on other related. So they're ordered to pay their own, and then percentage wise on the kids.
Yeah, the only caveat I don't know about, what's the insurance situation?
Right, we'll look into the insurance and see if you can look to see if there's a therapist. Okay, we'll do that immediately.
Because I guess there's a big difference, I guess, if it's just talking about splitting co-pays versus high therapy. I'm cognizant of the cost.
And obviously, as the court is aware, I'm concerned that the child support order in its current state is incorrect to begin with.
Well, my feeling is it's res judicata. So you know what? We can deal with that if you file a modification of child support. It's my position, Your Honor.
Okay, well, let's not deal with that right now, because there's no way I can even deal with it at this time today, but we'll take a look at it. we'll take a look to see what the status is of it, and I may be able to at least understand that position a better. What now, parent coordination. I'm sorry.
We do have a question.
Yeah.
I believe Mr. Asensio has the health insurance for these children, and that, would seem to be the first stopping point, is to find out through that health insurance if there are providers that will cover this, so we can at least start there and see.
Absolutely.
Yes, we will do that.
Okay.
Yeah.
Yes, a good suggestion. Yes.
Parenting coordination. We could put in a parenting coordinator for the summer and see if that is something that helps. I'm a little bit hesitant to do that. I'm not sure if that's a good idea because of the costs associated, but do you two, Ms. Pino, Mr. Asensio, do you know what a parenting coordinator is?
No.
I've heard of them, but
okay, well, a parenting
details.
I guess, to put it very mildly, a parenting coordinator is somebody that you can all call whenever disputes arise. So you don't have to call Mr. Lombardo, or you don't have to call Ms. Lanier. And I don't even know if I'm pointing in the right direction because we're on Zoom. But what you would do is, if these things happened, it would go, if some sort of dispute or problem occurred, it would go first to a parenting coordinator to try to address the situation. A lot of times they're very helpful because they're, basically third parties who could come in and help make, quick decisions or be just helpful to hear some issues. Obviously, they don't have the force of law. They're not a judge. The problem with them is that you're paying them on an hourly basis. So they get to be quite expensive. And I'm really haven't gotten much information yet, other than the financial affidavits about what the financial situation is with you all. But it may not be an easy task for both of you. Mr. Lombardo, what's your thoughts about a parenting coordinator?
I think it's a worthwhile item to investigate. The question becomes, I'm not sure who, and right now in Conroe County, is doing parenting coordination. We've been through a variety of them. But rather than, in my mind, if we had a way to check back in so that you could reserve on whether you want to order one or not in a couple of weeks, give Ms. Lanier and I the opportunity to figure out who's doing this and what we're looking at in a way of anticipated cost, so that neither of these parties are being put in a position where they're basically making a commitment that they cannot afford, and then we have a bigger problem.
Yeah, well, that's a great point, and that kind of leads me to something else that we're going to do, is that if we're going to continue this trial, and it looks like we have to at this state, I'm not just going to cut this loose. I want to make sure everything's going well. So I'm going to set this on for a status within a short amount of time, at least within a month, and we'll keep doing statuses if we need to, every month, or maybe even every 2 weeks if what's needed to do this. While we're talking, I'm gonna email my JA and see what we have for like a status, maybe about a month from now, if we have a time that I can fit you in for that.
That would be helpful, and that way we have a chance to figure out who's doing this and what we're looking at in the way of cost.
And that would be good too, because I haven't decided, I don't know if it's a good idea yet to hire a parenting coordinator, but maybe we'll know a little bit better in a month, depending on how the parties are behaving and treating ourselves, and how therapy and My Family Wizard are working out. Oh, let's see. How's June 17th at 1:30, just for a short status? I know, I happen to know Miss Lanier is available because she has a trial that day.
Yes, I guess I'm available, Your Honor. June 17th at what time, please?
1:30. So we'll do it right before your trial begins.
Thank you.
I'm available as well.
Okay. So we're going to set this. It's just going to be case management conference on that date. And I should have asked this ahead of time before I started speaking, but which one of you would mind preparing the order for this?
I will, Your Honor.
Thank you, Ms.
We'll,
Lanier.
we'll work together. We'll get it done. If Ms. Lanier will do the draft. We'll get it done.
Okay, so I'm not going to order anything with related to parenting coordination today, but that might be something that we talk about on the 17th. Is there anything else that we should discuss?
I guess it's just that the schedule, the parenting plan that's in effect will remain in effect during the summer, and they're both to abide by that, correct?
Absolutely, yeah.
Okay, thank you. And then we'll just come back, and I guess in a month, and Mr. Lombardo and I will immediately start looking for family therapist. I think Mr. Asensio, you can look and see who.
I can check in network.
Yes, and we'll work on this together.
Okay, Mr. Lombardo, do you have anything else before we?
No, Your Honor. Well, can I have one moment?
Absolutely.
Your Honor, would you like me to schedule that case management?
Yes,
for you?
please. That would be great. Thank you.
So in anticipation of trying to head off a potential problem for this summer, one of the issues with the current parenting plan is there's no distinction between school year and summer. So when it comes to when the parenting time starts, for instance, in her weekends, which are Friday to Monday, right? There's no clear issue or explanation as to when it starts when there isn't school.
Well, Your Honor, may I address that? The children are in camp.
Right, we got it set up where like camp then became like school in the summertime kind of.
Because the older daughter is going to be a counselor, and so it's important that she.
Oh, really?
She's good. Well, she's 13, so she's old enough to have it. It's called the Junior Leadership Program.
Oh,
and
good.
I believe once they get to high school age, it can become a paid position for them if they choose to continue it. So she just did her. She did all the requirements, met it. She did a CPR training, got her certificate. I just need to get her fingerprinted. But they'll be together in tandem. For the most of the year since age of 5, they go to Vineyards. So they'll be together in the same location. And in the summer months, the last day of school is June 11th, which I believe is a Friday. It's a half day. And then from that point on, the point of exchange would be if I drop the girls off leading into Mom's Weekend at Camp on a Thursday morning, Mom can pick them up at any time, whether we're at 10 a.m. from camp or whatever, and then drop them off Monday, or I meet her Monday afternoon at Target if they don't go to camp.
Okay, so what I'm hearing is that there may be there's some flexibility.
Flexibility would be greatly appreciated.
Well, it's actually
It's in the
order,
right.
Your Honor. It says in the summer when school's not in session, mother's parenting time shall be every other Thursday, pick up from camp and drop off the following Monday at camp. So it's pretty clear.
There's just been problems with that.
Okay. Well, are we both
Fridays? We usually argue because he thinks it's Friday to Monday, like regular school year.
No,
Okay.
we're all clear. It's Thursday.
It is Thursday in the summers. I'm fully clear on that.
But they
And-
should be in camp on Friday.
I mean, I would like them to go to camp, but I realize that's Mom's time. And I've had that discussion with the girls. It's come up before where and I said, guys, you know, that's your mom's time. You guys are going to play in your weekend and do what you will. I will get you Monday afternoon, whether it be from camp or in the Target parking lot at 5 p.m. And I'm okay with that.
All right, sounds good.
All right.
Mr. Lombardo, is there anything else?
I don't believe so, Your Honor.
Okay. I appreciate both you, Ms. Pino, and you, Mr. Asensio's flexibility during this week. And I do appreciate your flexibility too, Mr. Lombardo, Ms. Lanier. I know this wasn't an easy trial to handle. And I know that the timing was not ideal to be doing this on half days. And I thank you all for doing that and for your continued flexibility in this case. Again, no matter how the trial resolves, I don't think it was going to resolve issues better than what we may be able to do for you all from a therapy perspective going forward. I wish you both the best of luck during this summer in hopefully being able to co-parent what sounds like there's two wonderful girls.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Thank you, Ms. Mullen.
Are we leaving?
Yep.
Thank you. Good night. Bye.
Bye.